from from the vaping bill from protecting kids bill, from our consumer protection bill, constantly reframing it, to turn back to labor briefly at about 9. But now I found out that Acacia has joint rules until 9:30. We need to vote out a labor bill, and it will be, we need to answer, try and answer Randy and David's questions at 9-ish. We'll vote on it when Acacia gets back. So that is the only interruption. Other than that, we are really working on trying to get the bulk of this bill addressed. And so I am, we are now live. Welcome everyone back to Senate Economic Development and Economic Development, Housing and General Affairs. We today are turning our attention to the consumer protection part of our jurisdiction, and we will be looking at S-198, which is the basically the prevention from addiction of yet another substance, nicotine, an old friend of ours, and how we can actually have some impact on reducing the alarming rate of teenage addiction to nicotine through vaping. So we have some complicated tax pieces that we're going to be looking at with the tax department for the first half hour of our gathering. So Rebecca, we welcome you to the table, and I am let you introduce yourself and go from there.
Excellent. Well, great to be here. For the record, Rebecca Samaroff, Deputy Commissioner of the Vermont Department of Taxes. Yeah, and thanks for the opportunity to come in and speak on this bill. So tax is implicated in a number of places here. I think most exciting for me is the licensing transfer that the committee is exploring between tax and DLL. This is licensing wholesalers in this space, and DLL and tax are both very aligned in agreement that this is a good transition already. It's not often that another department comes and says like, "Hey, we think you should take this off your plate," and that is very welcome in this space. I think that we've over the years become very aware that the licensure information is a really key piece of DLL's enforcement and regulation in this space. So it's a little awkward when that's considered confidential tax data, and we've had ways to work through that, but we'll be much more streamlined if DLL is for
let's anchor ourselves in what sections we're talking about, because there are a bunch of things. There's licensure and there's tax, and we're hearing from the Department of Labor on some of the licensure pieces too. Yeah. So anchor us in the section. I have Jen. Is Jen Carby joining us? She did. Because we were just singing. Oh, a plug. State House Singers is singing at 3:30 with Chambers when the chamber starts. And I have our section by section that Jen Carby did for us sadly does not have the sections on it. But it is, we do have the summary of the sections, but just not the sections to anchor ourselves in. But we do have, I will remind the senators, we have the section by section.
So this is section 18. I'm jumping right ahead.
Right.
So this licensure responsibility is actually in this bill contemplated as a report that tax and DLL would prepare and bring back to the committee. And I think you're hearing from DLL later today, and you'll hear the same thing from them, that we really we're ready to make this transition effective July of next year, July 2027. I think they need some time to set up their infrastructure for doing the licensing, but we know at this point that this is a logical transition, and think it makes a lot of sense. So would suggest that we don't the committee not need a formal report from us. Hope that our testimony and alignment would provide that certainty that this is a good move. You'll agree with. One thing that section does contemplate is also having us report back on moving the whole taxation over to DLL. Neither department thinks that's necessary. It's very kind of like normal for us to manage the tax of an industry that gets regulated elsewhere. This happens with cannabis, hazardous waste, insurance premiums, like pretty standard course for us. And I think we're handling the taxation piece as well at the tax department, and so does DLL. So I think I can kind of give the spoiler of what next year's report would be, which is that we absolutely think that DLL should be responsible for the licensing and would appreciate keeping the taxation in our house. That's what we do best.
And my understanding is that so that is the work you're going to work on. You're going to report back on the whole move.
Right. So that's what's requested in section 18. My recommendation would be to just repeal that reporting requirement and go ahead and legislate that the Department of Liquor and Lottery will take over licensure effective July 1, 2027. And I think you'll hear that same recommendation from Commissioner Neidlinger today.
Okay.
Replacing section 18 is something to the effect of what you just said.
Exactly.
And we
yeah.
just need our if you could find out where Jenny is. I mean, we knew where she was 2 minutes ago.
Yes, so she does have to testify to the committees this morning. She's trying to pop in.
Okay. So we will if DLL is interested in it's that sounds like a natural move.
Yeah.
And let's not study it, let's just do it.
That would be my
Right.
recommendation. Yeah.
And that is that makes sense to the rest of the advocates in the room? Yeah, okay, great. Let them do it. That sounds good. And but Department of Tax is keeping all the tax work. That sounds very reasonable. Great. Good division of labor.
Great. Yes. Agreed.
Anything else that you
In that
further on the wanting to further study how you're going to do the stamp tax and all the stamping and all the other pieces?
Yeah, that is a section that I'd love to spend some time with the committee about.
Well, here's your opportunity.
Yeah. So section 8 contains a new system that requires stamping of.
Okay.
Yeah.
The section 8. I just need
I
to
should get there
find
myself.
where it is page. Yeah, it is page 18.
Right. So this is basically introducing a new system of stamping, tobacco products that, aren't just the standard cigarette packages. These would include like vapes and, myriad other things that Phil's been doing great work on, that have a variety of sizes and packaging styles and also potencies. And there's a number of practical administrative concerns about applying like the stamp format to such like a diverse set of products. I will be interested to hear what DLL has to say about this as well. We haven't gone deep on this topic yet, but from our perspective, well, first of all, I guess I'll speak to the timing here. The bill has this asked for this to be stood up this July, and that effective date wouldn't be possible for any changing stamp, because this is would be like a first in the nation move to have stamps on vapes. So there's kind of like the initial design work of what's the shape that works for the industry for something. I have a lot to learn about this industry in general, but lots of little nuanced shapes.
I understand this is a pretty heavy lift.
Yeah.
Does it make more sense actually for you to study this and spend some time working this out and coming back with a report on how you, really coming back to the legislature with a recommendation on how to do it? Because this does sound fairly complicated and involved. And if we're going to be first in the nation, taxing by differential amounts of nicotine in something, that's what I believe is being done here. Is that correct?
Yeah, and that's actually I need to learn more about if we would be first in the nation in that respect. I'm thinking about using stamps as kind of like the mechanism for flagging tax on on products that are just like, coming in a wider variety than just a cigarette pack. So I do think, what you're proposing is interesting, and let me like talk through some of the,
Which, yeah, because it
Concerns that
strikes
we
me
can
that this
get back to
actually
that question.
would benefit from further work. We certainly don't, quite honestly, we don't have the time to, before
of
crossovers,
course.
to dig into the practicalities and the of tax shifting to this. Because, right now we tax on weight and volume, right? I mean, so to move to tax committee to taxing by the amount of nicotine in something is a totally new way of doing it.
Right. And there's a layer of wholesaler price, I believe, too, in this tax structure.
Yeah.
Right. So those two
So
things.
the next side,
Yeah.
sort of the next version of an excise tax.
And the bill does, I think like the bill allows the commissioner to kind of like determine, that's like, that study work is what would be happening in house as we like determine what's like the best way to do it. So we could, we can talk about if it makes sense to make that a formal legislative report. But in general, the kind of things that, we would need to stand this up is, we put out an RFP for contracting for a stamp vendor, and then there's this kind of like novel design component there, which will be new, not just like, oh, like make more of the stamps we already do. That kind of
The stamps, just in case people don't appreciate the value of the stamps, I understand that when the flooding happened in 2023, the first thing the tax department did was head to the basement to get the stamps.
the stamps had to get out of the basement, and then there was like a whole process around deciding where to put this very valuable roll of stamps in our emergency operations space, which is not designed with the same security baselines that our department was. So yeah, it is.
See the after action report, place stamps on third floor.
Yeah, right. Nothing is in our basement, and I understand it's going to be filled with concrete. So
That'll keep the building from flooding, right?
yes.
No Kansas trips, right? Excellent.
Some good time capsule
So-
potential in there too.
Well, I guess the question is it a good idea to have a delay built in to give you the time to work through what else could go wrong?
Well, I
or
think
what could go right,
certainly, but I have some more fundamental questions about like whether it's a good idea
Exactly.
to use stamps in this context. Like, whatever the new tax structure is for these types of products, like kind of putting that policy question aside, we have some, just like practical questions as to whether stamps are like the way to, if they really have a role to play in helping enforcement here. Let me just like draw a comparison to the cigarette industry or, cigarette products right now, which is there's standardized pack and carton sizes, standard number of cigarettes per pack. So like the tax is very straightforward. It's, a levy per cigarette. But so a stamp goes on each standard pack. And then like the utility there is that like DLL or tax, enforcement will come into a store, look at all the merchandise, see it's all stamped, and they're like, great, we know that a Vermont wholesaler has, charged appropriate tax on this, and this retailer's paid that tax. It's kind of like a, line of sight enforcement check, which is great. So if you compare that to like the nuanced tax structure that this bill is considering, like this proposal, or there would be two different rates based on concentration. And there's also, like wholesale prices worked into this. So, as far as enforcement goes, if we have, just like one stamp that is like, kind of indicating like, yes, tax was paid, it only tells part of the story. An enforcement person could go into a store, see a stamp, but they don't know if that's like the right stamp, that tax was charged correctly for the potency. They don't know what the wholesaler price was and if the tax was levied appropriately for that. It's just much more complicated than like, yeah, there's a certain number of cigarettes in this pack and tax was paid. So
that,
yeah, that, so like, what like a tax auditor would do in this case. And what I think like a DLL compliance officer would glean much more information from is saying like, hey, can I see the invoices from this product so I can see what the potency is and what tax you paid your wholesaler,
So I would propose, given all the challenges you've cited, that we turn Section 8 into a work that the department that we would charge you with all the stakeholders and whoever we need to loop in to really have a full discussion of how we actually manage this and what might be the right way to capture what the objective is,
correct,
which is to raise the price of these so that we try and reduce the both the addiction and therefore the cost. Remember, we have to look at this holistically. The cost to this state of tobacco addiction and nicotine addiction is enormous. Not quite as high as the cost of the state of alcohol abuse, but
I would
look,
say education.
hundreds of millions of dollars the state is paying to treat nicotine addiction and tobacco addiction. So if we're trying to be thoughtful about taxpayer dollars, we're trying to be thoughtful about how we tax this to affect behavior. That's what we're trying to do.
Mhm.
So I would recommend that you work with Jen Carvey and whoever else wants to have input on what this study would entail and come back to us next week with some language on what the study would entail and when you think you can complete it by.
Yeah,
Makes some sense.
yeah, no, absolutely. I think it definitely make more sense to like study how stamps would serve, you know, the policy goals that you just laid out of this new tax regime. You know, if it's necessary to have a stamp component to that, or just
Well, if there's a 21st century, I mean, I think all of us would be open to 21st century solution to this. Maybe it's not a stamp, maybe it's something else. Maybe it's some laser thing, you know, who knows? But I think that maybe that some more time and more eyes need to be brought to bear on this proposal.
And in terms of eyes, I think like, you know, PLL has an incredible amount of experience and expertise here, and you know, and hopefully they're on the verge of aligning, you know, their licensing authority with their enforcement responsibility, which really like puts them in a great position, I think, to consider what's most effective to them in enforcement of this like whole system, especially, you know, oversight of product movement from wholesalers to retailers, which is like really where stamps
That's
come
where
into
the
play.
insights.
So I think like, you know, absolutely, if this was going to become a study, I would really, you know, love to work with DLL on that. And I would love,
And the AG's office would, I mean, who else needs to be involved? I think you think about it and let's.
yeah, but
David runs section 8, talking about the stamping of, and the taxing by differential, amounts for concentrations of nicotine. And I'm proposing that we actually move this because we do not have the time to get into the minutia of how this would work, nor does finance have the time to then take it up. So I would propose that we do this as a study, DLL and tax, coming back to the legislature, either, I can't remember, I mean, what would be appropriate as soon as you were able. Let's work on the date and the advocates may also want to have some input on that.
Yeah.
But do that.
Yeah, just like, you know, I'm thinking aloud here, which is always a little risky, but another
Well, I'm just thinking out loud. So it's
yeah,
like
yeah.
hearing the potential and then having discussed it already, I was like, you know,
So I think it's
not ready for prime time.
a study is definitely a prudent step. Like another alternative would be to give DLL the, you know, authority to, you know, like create, recommend, impose a stamp system should they feel that is like important to their regulation of the wholesaler to.
The combination of tax, which is currently doing it.
Yeah.
And DLL.
Well, I meant like in place of a study, you know, they could just like initiate or something, but I guess
I would actually think it needs to be actually thought out, and because it's because it would be levying tax on Vermonters, it needs to come back to the legislature. So I think DLL just doing it isn't necessarily what we want.
Yeah, sorry, I'm like very much separating the tax treatment, which is absolutely like needs to happen in this building. Maybe both sides do, but then with like this is really more of like an administrative tool, whether or not this tax structure is reflected in a stamping requirement, right? It's like it's an enforcement tool of a tax structure that could go in with or without it.
But it gives you the opportunity to actually rethink the stamp system
Sure,
all
yeah.
together and maybe come up with something even better.
So opportunity.
Yeah, it is. Well, I think it's an opportunity to rethink something that just because we've always done it the same way doesn't necessarily mean we have to change. We just need to accomplish the same objective.
Right. Yeah. So happy to participate in that. And yeah, whatever way the committee sees
That
that.
would be great. So we will, I'm sorry Jen isn't here, but we will work on that, and if you could be in touch with Jen and we could
Absolutely.
pray
Yeah.
on that.
I can initiate that outreach too, and I'm sure
That would
she'll
be
hear about it too.
terrific.
Yeah, happy to.
That'd be terrific.
Happy to.
And I can't remember if is that the last section that you, that, I think, are those the two things?
Yeah, those are kind of like the two big, administrative issues that I wanted to flag.
So
Yeah.
in 18, just to go back for David's, review, we're going to just let DLL, do the licensure piece. Right, we're going, your proposal is to, just let deals, instead of studying it, just, they will they'll transition to a new form of licensing. So that also we could, you might propose some language for Jen to,
Sure. Yeah, no, we're happy to support with that transition.
so instead of studying it, we're gonna hear from DLL and tax. I think everyone's ready just to let DLL do this.
Right.
And instead of studying it, and
Right.
instead study how we would impose, an excise tax or whatever we're gonna call it, the wholesale tax and a stamping system for a new way of taxing, really, which is by concentration rather than volume rate. Okay, is that summed up?
Yeah,
Sorry.
yeah, I think from our administrative perspective, that's sort of our big issues here.
Well, not just administrative, but hopefully
Yeah, I mean, on the
most
policy.
effective way to do it.
Sure. Like on the, I think these are important policy questions. I'm sure, it's not surprising this committee that, to know that the governor isn't particularly interested in increased taxes and fees in this space. So, from a policy perspective, this would certainly
He
be.
may not be, but I
Yeah.
think he would be thrilled at reducing the cost to taxpayers of this insidious,
Yeah,
opportunity.
no
So
question that this is a big nut to
This is a
crack.
huge drag on our budget.
Yeah.
Tons.
So I think this makes a lot of sense. Doing some quick Googling, it looks like, no other states have started to stamp the vapes, but they use compliance registries. So that effectively acts as a digital set of enforcement. And they have opted primarily for ad valorem wholesale percentage taxes. So yeah, let's study it, and figure out what makes sense.
Sure. Awesome.
Yes.
But you already.
No, I
answered it.
writing a lot this week about this topic, so appreciate it. Yeah, thank you for the time.
David? I think that's a productive way for us to move forward and pace. Yes, for this year.
Yeah.
Gives the governor a breather on that.
Yeah.
But
You had signed tax increase bill before.
he absolutely has. I've been here when he's done it. But I think this one is complicated by the cost that is incurred as a result.
Yeah. Agreed.
Any comments from the most invested here in the gallery?
Happy
Rose?
to connect. I'm Rose Kennedy from the
Oh,
HMO,
Rose,
so happy to
right,
connect.
Rose, you have any thoughts? Jill, Tina? Okay, this is, did you agree with sort of the direction of this, letting DLL license? And I know that's not okay, but Jen's gonna be here. I think Jen's. Thanks. That's our legislative council, who we're living in hope. It's Elijah's seat for the moment, but Jen will occupy it, we hope.
You can ask at the table.
Yeah, right, we can, exactly. So, okay, so everybody's okay with that? Those, great.
Yeah.
Any thoughts, Jill?
Jill Suntop, Aaron representing the Coalition for Tobacco Free Vermont. This seems to make the most sense. Just reminding the committee that the tax stamp on tobacco substitutes would not raise any tax. It's only that the products that are over 5 milligrams of nicotine, that would be the only area where there'd be any potential tax increase, and that is to really flag the very high nicotine products.
Right. So with that, we have 5 minutes before we're gonna switch to labor. Any pressing comments from our new members visiting? No comment, okay? And okay, well, let's take a break for 5 minutes until we have Sophie and Sophie's here. Oh, sorry, Sophie's here. So Sophie, why don't you come join us? We're moving to 2:30. We're not gonna take a vote until Keisha joins us after joint rules. Mike? Well,
We'll take a break until you're gonna work on another things.
We're coming back to tobacco. We're just needing to get this bill out. Okay. Gentlemen. You had concerns about self-attestation. That is the only piece I believe that is still, I think we're okay. My understanding is we're fine with the rest of the bill. But that there are, the self-attestation continues to be a challenge for some members of our committee. I would just remind us, we passed this exact language last year. I mean,
We didn't all agree.
what?
We didn't all agree on that aspect of that bill
You know-
last year,
Yeah,
just because it passed this.
correct. Thank you. I can't, although you know what, David, I don't hold those votes in my head, so I can't remember
Saying
that
that
we.
There is precedent, but
Mm. So, you're being consistent with where you are on it. Okay. So you are a no on that section.
it's not.
Which section?
Sophie, I'm just trying.
Page 3. Line of draft 2.
I'm trying to find 2:30. I've got. I don't even know where. Okay, take your.
I'm not seeing 2.1 on the web, but
It is too. Yeah.
Yeah, find it. Oh. It's here. No. Where? Like it's in there. Sophie's pulling it up. So am I correct in, well, Sophie's pulling it up. Am I correct that people are okay, that the committee is okay with the first two? With the first piece, of 2:30?
in front of me, so
I don't have.
Okay.
I click on 2:30, I don't see the draft 2.1 show up on the public area.
We have draft 2.1, I think, Sophie, and we all have, and she did a summary of it. Sometimes, so, I believe the first section, draft 2.1, which is the, aligning teachers with the federal, Unpaid Family Leave Act.
Right.
Family Leave Act. That people didn't have a problem with that. We did. And we found out that the only two other occupations that are eligible for this alignment are,
It's teachers and the airline flight crew, so
Yeah.
it should not have a parade of folks coming
Right.
in.
and then, so Sophie, take it away.
Okay, so
Am I correct in understanding nobody had a problem with it? Right, great.
No, but if you're gonna do a section by section through this goes forward, how would you summarize succinctly what this is really doing?
this is allowing teachers who are eligible under the federal medical leave act to be eligible under the Vermont Parental Family Leave Act. There's different eligibility criteria between the two acts.
Okay.
And they're allowed, again, because their hours are are different as our airline crew. There's a special provision for them at the federal level that allows them to be covered by the FMLA. And so what this is doing for both the airline flight crews and now for the teachers is just saying, if you qualify under the federal definition, you're going to qualify under the state definition.
And there's no other groups in the federal legislation that calls out
Those
unique group of workers because of their work ethic.
Those were the two that had this special rule as far as I could tell.
Does anybody else do this, the state?
I don't know off the top of my head on that.
I've not, this is the first time I've heard of this year with this.
No, we did it last year for the airlines.
Right.
Well, the airline I'm aware of. I'm saying anybody else
Right, well,
in the world treat teachers this way.
I don't know that off the top of my head. I think because you did it for the airline crew and that kind of came late in the session on the
The airline
girl.
crew was a special situation, well known that there were different rules because the backbone things that they don't get paid until
Right.
the plane takes off. And there are a lot of things that are unique.
but
And I
I,
wonder why should they be so unique for teachers as opposed to other professions?
I think it's because teachers don't teach all year long, so they're unique in that they are like airplane pilots, they are unique in that they have sporadic
Well, there are
employment.
all kinds of people who have
We're
seasonal
unique too,
employment.
sporadic employment.
No, and exactly. And that's my point is that there are lots of people who have periodic employment that is either seasonal in nature or based on certain circumstances.
But
Why are
this,
teachers different?
right, this in law, and it calls out these occupations. And so I think as much as possible, we should align
In
them.
law?
So the federal laws, that's my question.
Right.
Is there a conflict right now where they would qualify federally, but not at the state level that we're resolving by synchronizing these two?
Right.
Yes.
So right now they qualify at the federal level if they meet the federal definition, as do the airline crew, if they meet the federal
Say
definition.
that again.
So right now, full-time teachers would qualify for FMLA if they meet the special definition that's in the Code of Federal Regulations for teachers, same as for airline flight crew. And so what happened in the last session was scooping in the airline flight crew and saying, if you qualify for FMLA and under the federal regulations, you will be deemed to qualify under the state law, under the PFLA. And so the request this session was to, if you've done it for airline crews, can you also do it for teachers? So that's what this proposed amendment is doing, would be looping in teachers that qualify under the Code of Federal Regulations.
Rich, and I think it was our bad last year. We didn't ask what other professions, and we should have done this. We could have done this last year and just done it all at one time. But we didn't.
Who else is under this that may qualify? And ultimately, if we follow the same logic.
Nobody has. That's what Sophie's found out.
So my understanding under the FMLA is that these are the two special categories, that you're not going to have a parade of other people coming in and saying, me too, me too.
Is this
Todd.
federal definition referenced? I'm fine with this, but
Yeah,
I'm just trying, we're getting ready to vote this thing out. I just want to know.
Right to know what we're potentially getting into and why.
So the federal definition, is it like 50 pages long or is it relatively short that we're synchronized with? You have that quickly?
I have it. I may even have it on.
You're looking to vote this out today? Is that
Yeah.
correct? Okay, so then I think it's a valid conversation.
Some of the questions is answered.
We do 8:30 tomorrow. Too. I'm sorry, put you on the spot. So
Okay.
you're
I
gonna
just
find
am
it.
not going to find that. Well, I can say that.
I can Google it too.
I have it all ready for them when we walked through this the last time, but I put it there. It's not huge. And it's got I put the extra cross-reference in there. Because
In your
it
summary?
references, yes, no, in the bill,
Oh, right.
because it says full-time teachers as defined by. So 825.11.110C3
But then it says
states, in the event an employer does not maintain an accurate record of hours worked by an employee, including for employees who are exempt from FLSA's requirement, the rep will be kept of their hours worked. The employer has the burden of showing that the employee has not worked the requisite hours. An employer must be able to clearly demonstrate, for example, that full-time teachers, see section 825.102 for definition, of an elementary or secondary school system or institution of higher education or other educational establishment or institution who often work outside the classroom or at their homes did not work 1,250 hours during the previous 12 months in order to claim that the teachers are not eligible for FMLA leave. So that's basically, it's just shifting the burden. So the burden is going to be on the employer to clearly demonstrate that they do not qualify. And then again, the definition of a teacher or employee employed in an instructional capacity or instructional employee means an employee employed principally in an instructional capacity by an educational agency or school whose principal function is to teach and instruct students in a class, small group, or an individual setting, and includes athletic coaches, driving instructors, and special education assistants such as signers for the hearing impaired. The term does not include teachers' assistants or aides who do not have as their principal function actual teaching or instructing, nor auxiliary personnel such as counselors, psychologists, curriculum specialists, cafeteria workers, maintenance workers, bus drivers, or other primarily non-instructional employees.
I don't have any concerns, so now I just have a better understanding what it would do.
My sense was that we were fine with this section one.
It goes, same question that we've been asking.
What?
The question is, why are teachers, aside from the fact name, why are they getting this particular benefit and other occupations are not?
Graham, we have an expert in the room sitting behind, Sophie's an expert too, but sitting behind Sophie is Colin. Colin, would you like to weigh in on this?
Sure. For the record, Colin Robinson, Vermont NEA. I just want to step back for a quick minute and point out the language that Sophie just read points to it's language that it gives teachers the presumption of eligibility, and therefore that doesn't automatically guarantee them access, right? And that would be determined through a normal process with the employer. And
Does that mean that some employers would and some employers would not?
no, they would just look at the facts of that individual teacher's eligibility, and the presumption is that a full-time teacher is presumed to work the requisite number of hours to be able to access this. And there's been this inconsistency that exists for airline pilots and flight attendants and teachers in between what is presumed under federal regulations and the presumption in Vermont for some time. And so this is just sort of making sure there isn't that confusion. It's clarifying and recognizing that if one is able to access federal leave and have that presumption, unpaid federal leave, that same presumption is available under Vermont's unpaid leave. It's just rectifying an inconsistency between the presumption.
I understand the pilot situation has been a long-standing one. I was not aware until we got into this, we had to press this, that teachers are like pilots. And I started thinking about, well, what are the parallels? Why is there a connection? And I can understand pilots don't get paid while they're waiting for passengers to board the plane, for example. Well, teachers get paid when kids go through the door to go to school.
Yep.
Whether they do or not, they get the same income.
And teachers don't get paid when they're doing their lesson planning on the weekends or gradings on the weekends.
Neither do lots of other people in jobs who, take work home with them.
Yeah. Again, last year, this committee and this body made the choice to align federal regulations for one group of workers that the federal government has recognized.
Recognize that the federal government doesn't always do things that are logical or sensible.
Well,
and as we may be in a rush to do something last time, I didn't hear anybody asking these questions last year. At least to a great extent.
I think we did. I think we did a fairly thorough job of reviewing it. But what we didn't do is ask the question of what other professions fall in under this misalignment. And we have discovered that this is the other profession that does. And if it's in federal law, this is unpaid family leave, remember, this is not a massive benefit. It is simply unpaid family leave. Thomas.
So your concern center, Brock, the way I see this as solving a potential problem is a quick Google, and Googling a lot when we're doing this. The most litigated definition related to this, as that I can see, is the serious health condition, and the federal regulations have restriction on inpatient care, meaning an overnight stay in the hospital, must be or continuing treatment, generally requires a period of capacity. My point is the federal definition seems a little more robust, whereas if we stay silent on this, it's potential that we might have more inconsistent and possibly more liberal interpretations of what would qualify for this. So I do see some merit in aligning with the federal rules, because there could be a teacher, somebody trying to apply the federal standard, but then maybe getting a Vermont for treatment. And it might actually be better to have one consistent standard that is clearly applicable.
My next question, of course, is what, if anything, does this cost?
Those questions have been asked around the unpaid leave, and I don't think there's a
I don't think
there's a
an
good
answer
way to
yet.
track it, because a lot of times it's just worked out, you know, the employer and the employee. So I don't know that there's any, because I think that's questions come up before, and my understanding, so it's really a good way to quantify that.
Well, I guess the question, you know, and how relevant it is to what we're talking about here, but does that then lead a teacher to say, well, I do lesson plans at home and it shouldn't be unpaid, it should be paid?
Well, then they can negotiate their salary when their salary is up
The next
for
question
consideration.
that people would logically ask is where this takes us. And then when we say, well, Vermont does compensate, or does consider that in certain of its policies, such as this one, add weight to the fact that this is compensatable.
Is this not all in the unpaid leave?
Yeah, this is all unpaid leave. So this is costing an institution time but my guess is it's made up. I mean, that is between the employer and the employee.
It's really just the eligibility piece. It's just,
Yeah.
are you eligible under the Parental Family Leave Act? Because it is a more generous act than the federal medical leave act.
As the spouse of a fifth grade teacher, I would really like to raise that spouse time should be.
Yeah.
Amen.
Yeah.
Second that.
Yeah, the both of you. So are we okay with section 1? I'm fine with section 1. Thomas seems to be.
I'm okay with it. It's in line with the section.
Yeah, I mean, it's the most straightforward. I think if we're okay with section 1, let's move to the issue of self-attestation. And I realize, thank you for reminding me that we may not have had a unified vote on this last year. And people may have had the same concern. I was thinking, speaking of being consistent, let's align ourselves with what we did last year. If there are any additional questions on the self-attestation, that's my. I think, I guess I fall into the line of, I trust people that when they've had a traumatic experience, they're not gonna take it out. This is the implications of it are just too big. And so I guess we self-attest all the time. You and I self-attest all the time here. We self-attest to our expenses. We self-attest when we do a lot of different things. So I think we both have to trust ourselves and trust. We have I'm sorry Charlie isn't in the room, but I don't believe we have had any, I recall in her testimony, we have not had any reports of anybody taking advantage of this. So the employer can always challenge it. It's not like it is, in stone. An employer can challenge this. And there's the validation. My other note is there's the validation of additional things the employer can ask for: legal, clerical, medical.
Looking at the language again.
Yeah.
Picking up to this conversation previously. So I see in line 17 of page 2, where it's saying if a person who is a survivor of domestic violence, sexual assault, or stalking, and who has supporting documentation from any of the following sources. So the supporting documentation is that key piece that even in the self-attestation, it needs supporting documentation. I hear your concern, is it terrible? What if we had qualified supporting documentation just to make sure that the supporting documentation isn't accepted at face value without further consideration? I mean, would a qualified term be at all to address the potential concern of illegitimate documentation?
Well, so line 18, supporting documentation lists self-assessment to being a qualified document. I guess push it down.
If by adding qualified, would that somehow?
Well, I don't know what it really means.
The
I
employer
added
qualified?
the possibility of, on line 7, self-attestation, comma, under oath, comma, by the person describing the circumstances. That under oath doesn't mean you have to do anything other than sign something for a notary. But again, it becomes an oath and it locks in a statement, and there are then certain penalties for lying.
Yeah, it's
Because-
just something I can't even imagine anybody lying
I
about.
can imagine people lie about all kinds of
That's why we have
I've
judicial
done that
assistance.
for years.
Well, we've had no experience of people lying about this so far. The AGs, I mean, we've heard from a number of sources. I mean, this is not something tend to lie about. Being raped or sexually abused or a victim of domestic violence. I mean,
I've seen lies in those situations.
well, I hope you
Have
can.
asked. I have seen them on more than one occasion.
Well, then then there we are. I mean, I just think that, under oath may be, sort of violate what I think the victim advocates are. And the victim advocates aren't here, so it's a challenge at the moment to
Is there a,
answer that.
so I don't know what the burden is, or what the financial burden is out, but compare how frequent the available notaries are, not necessarily opposed to that. I think we would need one more testimony to know that that does carry with it a higher legal bar. But what about if they're qualified who has sworn to supporting documentation, which would include notarization?
A sworn self-attestation.
Sworn to.
What does that imply, Sophie, as our lawyer?
Same thing.
Yeah, that you're have to, under oath that this is, I guess, and for me, the question is in practice, what would happen, right? If it turns out somebody has, I just don't know how it would play out in practice. Is the lawyer going to go after them because they submitted something and said it was under oath and it wasn't under oath? I don't know. But I mean, obviously it's a policy decision by the committee in terms of what you want to do.
The reason why I like the qualified, not against the under oath thing, but the qualified, I could imagine a scenario where somebody writes a sentence.
You send Charlie to us.
I was put in here, and then that's the whole statement, just one sentence. That seems a little too vague, and I feel like adding qualified supporting documentation, the employer could say, we don't see this as qualified as that it lacks detail, specificity, validation. So that's where I thought it might have gone to those concerns, but
I mean, it
So
does.
Charlie's gonna zoom in with us in 1 second. Sorry.
And I would say the current language is a self-attestation by the person describing the circumstances, supporting the person's status. So I think they would need to be more than just a single sentence.
so that would be, could be disqualified with the language as it is.
Yeah. So the victims advocates gonna weigh in, Charlie Gusserman. Rose, as the AG, do you have any comment here? Because I think there was some. This is fairly, is self-attestation. I don't mean to put you on the spot, but while we're waiting for Charlie's, self-attestation occurs fairly regularly through our statutes and through our abilities to qualify for things.
So I feel like I'm talking a little bit out of my former lane.
Okay. Remember, Rose Kennedy was state's attorney of Rutland County.
I mean, I think your question about if it was just a swearing statement, what does that mean? How much does it hold? I think under like a perjury statute, it'd be kind of tough, I think, to pursue anything. But I haven't looked at this in a while, so.
Okay.
To that question, if
Yeah.
it was sworn by a notary, then does it hold more weight for perjury
I think
claim?
there's specific language that the statute has about I swear to this and under the pains and penalties of perjury, I guess that it's accurate and, truthful to the best of my ability. I think that key language is important if you want it to be that strong.
So we have, what's Todd's title?
Legislative liaison.
We have Todd Delos is going to zoom in to join us and Charlie. So if we just wait 2 seconds, we're going to get an answer on both.
I just want to acknowledge, I know we're in trouble when I try to start wordsmithing, so.
No, we're not. You're trying to help thread the needle, and I appreciate you trying to help thread the needle.
I mean, the other piece I would say is, whether someone's had it notarized or they've self-attested, if the employer has reason to think they've lied about it, that would be forced disciplinary action one way or another. So,
Exactly, and the employer is perfectly capable of challenging this.
right, and again, you can't, if you lie.
Right,
Your
that's a
position,
crime
that's
right
right,
there.
it's a subject of discipline, that, you could have an action taken against you for that.
Right. Okay. Oh dear.
When you notarize something, when I've gotten a notary, I don't recall the notary actually reading. They were just validating that it's me.
Correct.
So it's not like they have to review the documentation. They just want to validate that I'm Tom and I'm signing this in front of them. And then they
Yes, they're signing it
Correct.
on the basis of it, again, depending upon how the attestation
Okay,
that you
let's bring
sign
that.
may indicate that this is
Well, we can't
signed
see it, so let's
get
rid of whatever
comply
it
with
is.
section 4 of this, et cetera,
Okay, we have the AG,
for the specific purpose.
we have the AG and we have the victim's advocate, Charlie Glisserman and Todd Delos. Welcome. Thank you. We may need your help here. We're trying to thread the needle on self-attestation yet again. And whoever would like to go first, Todd, you have some thoughts on self-attestation?
Thank you, Chair. Todd Delos, Assistant Attorney General at the Vermont AG's office. Thanks for having me in. I think it's important to go back to some of the testimony last week around what truing up these two definitions means and what role this definitional change would play. This, again, is moving this definition that, as the chair indicated, already passed through the Safe Leave Bill, Act 32, last session, to the employment protection section of the law. And this means that an individual who is subject to discrimination, harassment, or some kind of negative employment action could seek legal protection if they can demonstrate, and the burden is on them to demonstrate, that the action was taken because of their membership or because they belong to a protected category. And here, all this bill is doing is saying, akin to safe leave, if somebody can demonstrate through any of these items, including self-attestation, that they are a victim of stalking or intimate partner violence or domestic violence, then they can seek that as a claim. But it's really important here to the point around self-attestation, the concept of getting it notarized. All of that has to play out in court as evidence that an employer would basically say, no, you're not, or I terminated you because of X, Y, Z, nothing to do with your experience as a survivor. And so I just want to understand that idea of someone swearing to the document that demonstrates their status as a survivor, whoops, I didn't mean to raise my hand, but the computer thought I did, is really much less important in this context, because at the end of the day, if a claim is going to move forward for discrimination, harassment, et cetera, the burden's going to be there on that individual to show that they have that status, independent on some level of the self-attestation. It's just a means by which they can, in an initial phase, demonstrate that. And I think the more burdens, and I'll let Charlie speak to this, the more burdens we place on individuals who have already undergone a traumatic experience, the harder it's going to be for folks to come forward and protect themselves.
Thank you, Todd. Charlie?
Thank you for having me in. Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I certainly second Todd's comments from the Attorney General's office. What we are hoping for here is to provide survivors of the same kinds of protections they have in the workplace under unpaid job protected leave and ensure they have access to those protections under the Fair Employment Practices Act. I think aligning the documentation will appropriately provide for that. And Todd was exactly right that when we're thinking about what survivors need to access safety, we're thinking about accessible forms of documentation. I think there's a reason why the documentation list that was included in unpaid job protected leave was structured how it was. So survivors can access relief in the workplace without unneeded barriers. So I don't have too much more to add other than that in my past testimony, but I would be more than happy to answer any questions.
Am I correct, Charlie, in understanding that we have to date no reports of abuse of self-attestation in this regard?
I have not heard any, no.
My question is for Todd. The language on self-attestation here, if we were to add self-attestation under oath by a person, would that make any difference, or would it not make any difference to be worth doing?
I think it would make a difference for the individual who is seeking the protections. As Charlie indicated, it would be another barrier. I think the case, Senator, at the end of the day, you know, AAG Kennedy indicated sort of, would there be a criminal prosecution for somebody for perjury in this instance? That seems pretty unlikely. What experience with if an employee was dishonest in claiming status or taking leave, that independently could be grounds for termination, and that would be the crux of that, you know, case, for lack of a better term. So whether they swore to it or not, if it turns out not to be true, then they don't have the protections under FEPA, and in fact, it could be grounds for termination independent. So, in brief, I don't think it really moves the needle significantly in that world in which someone is, which we haven't seen, but that world in which someone might be dishonest in seeking these protections.
Yeah, Todd, I'm going to just jump in. Did I just hear you say, and should I refer to you as Attorney General Dallows? Okay. I'm going to call
Assistant.
Did I just hear you say that if somebody put in a self-attestation and the employer deems part of it to be factually false, that they could terminate the individual on those grounds?
Well, so I don't want to get into too deep into hypotheticals, but essentially, right, somebody being dishonest in their job could be grounds for termination, right? And so, and that's why the concept of having it sworn to, I don't really think shifts anything, because if they're going to falsely swear, then that's not gonna matter.
Well, the only thing that I would ask, and again, I'm not sure how much experience you've had in dealing with people in an employment situation live, but would having to sign self-attestation under oath be at least effective to some degree in discouraging people from lying?
Yeah, it's an interesting point, Senator. I guess I want to go back to sort of where this law sits, and where this law sits is really someone claiming protections for and membership in a protected status. And I think the self-attestation here is really much more about an individual being able to say, I was fired because, and less about, I'm going to take leave or I need this benefit. This is really a protection, not a benefit. So I think as I play out the potential litigation here, again, this is someone saying, look, you only fired me because I took safe leave, because I was a victim or a survivor, or I've been, you know, subject to stalking and that's why I was late to work or what have you. That then becomes a conversation around, was the employer aware? is this a legitimate ground, et cetera. I don't know as whether that's notarized or not will matter, because ultimately it's going to be a sworn deposition in litigation, right? You're going to end up in the same place.
We're gonna end up in court and then we'll all, yeah, Thomas.
I'm not against the under oath piece. Is under oath clearly interpretable as a notary? If that was in here, or is sworn to, is that a better, how do we make it so that notaries could move this forward to get people comfortable with this language?
Or, yeah, I guess Charlie, do you want to answer that? Because it does create another barrier.
Yes, I think having a statement that's sworn under pains of penalties of perjury that the individual survivor is certifying to the accuracy of the statement is a more accessible option than having a document be notarized.
Okay. Thomas, would that be?
Did I say you sworn to?
Yeah.
Yes, that's exactly right. And, there is actually a bill moving in the House that has similar language around swearing to a statement's accuracy. And I'm happy to send that over to Sophie if it's a helpful example.
Is that possible for you to do in real time at this moment?
Absolutely.
Great. What bill was it in? I know, well, I'm not gonna interrupt. You send it to Sophie and then we'll talk about it when we hear the language.
Perfect. I will do it now. It's in H385. It's the coerced debt bill that is in House Commerce and Economic Development.
375.
No, 385.
385.
As introduced?
No, it is in the latest bill draft. I'm happy to, if I have permissions to share my screen, I'm happy to bring it up.
Yeah, let's do that because we need to get.
So the language reads, the statement shall include the following language above the debtor's signature and date. I declare that this statement is true and accurate to the best of my knowledge and belief. I understand that the above statement is false. I will be subject to the penalty of perjury or other sanctions in the discretion of the court.
Okay, so this is the language. I declare the above statement is true and accurate to the best of my knowing and belief. I understand, and that is a self-attestation.
What's this?
But I'm swearing to it.
Is this self-attestation, the language, is it used in connection with court proceedings specifically? Are there court proceedings involved here?
Where's that?
Well,
so it actually, I think, is a really interesting comparison to this because this statement is being provided to a financial institution and it could eventually be litigated, end up in a civil court. But doesn't necessarily have to be. And so I think it would actually play out in some ways comparable to providing documentation to an employer that they either could accept or end up in litigation.
And I would ask Sophie, as our counsel in this, would you see any objection to including that kind of language for this purpose?
No, I mean, you can certainly include that into this bill. I mean, again, you'll have that discrepancy between the language under FEPA and the language under the Parental Family Leave Act.
It's acceptable to me. Again, this always has a problem with self-attestation in general, but I'm willing to accept it.
you okay? And so how would we, and might we see a new copy of this, or can we, because obviously the beginning of C lines 13 and 14 need to be adjusted.
Right, yeah, no, I can work that language in and bring it back to the committee.
Okay.
Now, the only thing I think that we've been discussing is potential differences is why does this apply to teachers?
But it does. So
No, I mean the overall.
Well, I think we've answered it to the best of our ability, which is federal law included teachers. I don't know why they did, but they have. And what we're trying to do is align those for our state teachers. And in fact, Thomas pointed out, sadly, the federal law is less generous than the Vermont law. So,
And the other question, which I know, partially is why, does anyone know why federal law treats teachers this way and no other occupation other than pilots?
There's a special class of group. We also get a
and a
tax credit.
special class, and people who live with them
You
know that they're a special class.
And-
David,
That and they have a very strong lobby.
Exactly.
has
To their credit.
no,
Teachers are important.
teachers aren't.
Well, if legislators got, lobbying support the same way, I might go along with it.
Well, perhaps if we were paid as well. as
Nobody likes
teachers.
legislators. They like teachers.
So Sophie, are you able to redo this and bring this back to us before we break at 12?
It's,
But I don't want, okay, I'm gonna be really blunt. I don't want Sophie going to this effort if we're still gonna vote no. David?
Yeah, if I could, I just want to add some context to this. So the unfortunate truth is we all, but I'll reflect on myself, that have far too many family members, friends who are the victims of sexual abuse. That's the unfortunate reality. So I'm not trying to put roadblocks in front of this, the effort to include them as a class under this definition for a crime victim. Okay, that's the whole intent. I get it. Okay, so now that I believe this language, we've resolved the self-attestment issue, and I'm on board. So I'll support that. And so to your point, yes, I think that's a sufficient remedy. Disagree.
So with this change, you would support
Yes,
this
ma'am.
bill? And Randy, okay,
Yeah,
Ben.
I will support it, but the same reasons that Senator Weeks has mentioned, that, being fair to people, but being fair to all people is what I'm concerned
Yeah.
about more than anything else. And the question that I have regarding this bill is it being fair to two classes of people, pilots and teachers, when there are other employee groups who deserve the same kind of protection for one reason or another, and they're being excluded? And the only thing that I can see as to why they are separated out and being excluded by and large is because they have good representation.
David.
Yeah, so this is our only labor bill we're intending to get out before.
Yeah, 173, your bill. 173 is our labor bill that's already gone out. We have two labor bills.
This
This one and 173. Yeah.
So I would like to propose for your consideration, for the committee's consideration, that we pick up a section of H 842, section 3, which deals with education, healthcare negotiations, which we do happen to have the NEA in the room to comment on. This is specifically addressing where we get into, again, teacher healthcare negotiations at the point where the mediator is involved. That currently a mediator is required to take only one argument or the other and not blend the two arguments. And this section 3 of H 482 would remedy that, would allow the mediator to take pieces of parts for a compromise solution as opposed to either A or B.
Where is that bill at the moment? Because if
It's stuck on the wall.
general housing.
Yeah.
On the house side.
it's an H bill and it hasn't made it over.
It's not in a wall.
That would derail this bill, I think, just in terms of
It would
time.
delay it.
Yeah.
But it sounds like we have support for the bill as it exists. I'm
And it's
testing the
good.
waters.
Yeah.
This is the- So we took testimony on the
Yeah.
finance and Senate finance, said, well, this is a labor issue. And so that's what we said. You need
So this is the piece that we were going to talk about, okay?
There's a lot of support from the Vermont School Boards Association to address this because they are stuck in this position where they have to choose one or the other. And they know, the mediators know that there's a better middle ground solution, but the language doesn't allow them to come up with it. So it seems like a reasonable thing. I support it. I think it would address our healthcare issues.
And here we are heading into town meeting week without we're not addressing the healthcare issue in the education landscape. This is minor.
Okay.
Permission to share, I can, is that okay if I share that?
Yes, and then I'd also like to hear from Colin. While you're working on sharing, Colin, would you like to weigh in?
Sure. Again, for the record, Colin Robinson, Vermont NEA. As Senator Chittenden mentioned, there was some initial queries and testimony provided to your colleagues in Senate Finance on this. And I think what that hearing and that conversation exposed is that, and as this committee knows, when it comes to collective bargaining law and statute and processes, it's complex. In this particular case, we're talking about a benefit that is going to impact over 35,000 Vermonters. And quite frankly, as I think Senate Education heard from the chair of Senate Health and Welfare a couple weeks ago, the underlying premise that changing the collective bargaining process is somehow going to make healthcare more affordable for anybody is a false notion. We have a healthcare affordability crisis for all Vermonters, and changing the bargaining statute is fundamentally not going to address the underlying problem. And that's why Senator Lyons and her committee has done good work, including creating a situation where the VHI, the pool that provides healthcare benefits to public school employees statewide, is going to realize $40 million in savings effective July 1 this year due to decisions made by the GMCB, due to the infusion medication cap law you all passed last year, and decisions made by the VHI board to bring down costs. So that is $40 million of savings realized to taxpayers and school employees who pay 20% of their own paycheck every single week that they get paid. And so unfortunately, this provision and the collective bargaining statute is not a remedy to what is a healthcare cost crisis for everybody. I would also say that, as Chair Clarkson pointed out, this is an issue that is of great concern to both school employees as well as other interested parties. And fulsome and robust debate and conversation about this issue would be critical to ensuring that if the community is interested in pursuing it.
Thank you. I think, David, hold on one sec. My feeling is that we have probably an hour next week to address this. That is insufficient time to address something this big. What I think we can do is use this labor bill, because they're not sending us a labor bill. We can use our labor bill as a way to really put pressure on House General to take that up, because it deserves the time. I mean, this is a big conversation. It's not such a small conversation. And I think we'd have to show in context of the education cost reduction efforts that this would have any impact on that. I just literally don't think we have the time to give it justice. I'm happy to represent, as I would hope everybody at this table would represent to the chair of House General, the import from our point of view of their taking that bill up and giving it due consideration, as they have two labor bills coming at them for consideration. Actually, they only get one. Workers' comp will go to House of Commerce. And I appreciate, David, you raising this at this moment, and Tom had raised it earlier. And it's a big labor question, I believe, and one I just don't feel we have time to give it justice. It's my honest response at this moment. Yeah, Tom.
Let's just say, we're not talking about taking away benefits. So it is a conversation with lots of interest, but this is about a tweak to current law that might get us to a place where a lot of people, taxpayers as well as teachers, still come to a reasonable place where they get good healthcare coverage at a price that Vermonters can afford. So I'm not opposed to having this discussion. I wonder if, since there's interest to move this bill along here, could this be an amendment we consider for it afterwards?
Absolutely, we could, because that bill will come back to us, and we can, and there may be discussion. But I think it would be really helpful for the House, who has much more time than we do. They have double the time we do to take this up as they get our bill. And I think in all fairness, that would give the issue the time and effort and the light it needs, because it sounds like it needs some serious consideration and discussion.
We should hear from the school board side. I think they have a compelling argument for us to consider this.
Right.
Are you familiar with this topic at all, Senator Rob?
I mean, I am. I was trying not to comment on things that might have been discussed before I got
So-
here. Is it just
So
that?
David
piece?
is proposing
Yeah.
that we add to S 230
Uh-huh.
at this point. This provision in H3.
842.
Mhm.
42, section 3,
Eight.
just the negotiation.
The picking and choosing. So there's,
And what section is it?
so in Senate Education, we've looked at the longer, or more multifaceted school boards association proposal that I think has other provisions we might consider. And this one is one where I think we really need to know how often the VLRB or labor attorneys are in labor law, how often we are allowing an arbitrator to pick and choose different provisions to make up a whole agreement. That, that is why this issue is before these two committees, is because that could have serious implications for other areas of labor law. And it wouldn't be the first place I would go to try and impact, the overall
Cost
cost savings. There are other pieces of the bill that sit in House General that they've been I think they've at least been looking at informally that, might give us a framework for talking about this that doesn't impact all of labor law.
So, at this point in the session, where every minute for the next week and a half is accounted for. We already have you coming in at 8:30, and I don't want to take away all your lunches. So I think that at this point, I would really like to work with the chair of House General, and I will advocate for this as we have our Wednesday morning breakfast at 7:30. I will advocate for this to be taken up when they take up S 230, because S 230 will go to their committee. And I think it's fair to have a full conversation. I think I'm hearing we have to have the VLRB, the NEA, the school boards, and some teachers. I mean, this is
It's quite a lift.
I think it's a big lift at this point, and I appreciate this conversation. Thank you. And I appreciate whatever you've had in education, but I think that at this point, I would ask that we leave this consideration for after crossover with House General. And I will advocate, and I would hope maybe we could have the chair come in and chat with him about how important it is to us. Is that okay?
Thank you, ma'am.
Thank you. Okay, so to bring Keisha up to speed, I'm hoping with the new provision that Sophie has worked on.
Worked on it, yeah, I will.
Okay. So we've gotten to, yes.
Yeah.
If we include this language. Great.
So it would be just adding into crime victim status under the self-attestation, some language around that they're submitting it under penalty of perjury.
Okay.
You're gonna pull that together and maybe we'll vote on it.
So if we could if it's possible for you to bring back to us at 11:50.
Yes, I'm in another committee at 10:30, so I will do my best.
Okay, great. Thank you. Appreciate it. And with that, I think just given everybody's been sitting. Okay, I know, and I have Thomas Chisholm on my right. Why don't we take a break till 10 and we'll reconvene? How was joint rules?